All right, got the recording going. And today we're going to begin our discussion of the law of eminent domain, the power of the state to take property for public use as long as it pays just compensation. So that is set out in the United States Constitution, the Fifth Amendment. Nor shall private property be taken for public use without just compensation. So the law of eminent domain basically gives the government a power to force a transfer of property rights from private citizens to the state. How about, is Mr. Julius with us today? Donovan, you here?
Yep, I'm right here.
All right. Does the government need to have the power to force citizens to transfer property to it? Could a government operate effectively without the power of eminent domain?
Well, there's a historical argument to the contrary, saying that they kind of need to be able to do that. But I suppose they don't have to go through eminent domain. There's other ways of going about it. They could just negotiate with the people who own the property.
So you could tell the government, do what other private landowners have to do, that if they want more property, they go out in the marketplace and they find a willing seller and pay the price that it takes. Why do you suppose we give the government this power? What kinds of things might the government need this for, where just telling them go to the private marketplace would be problematic? So you allow the government to do that it couldn't do just if it were relegated to transactions in the marketplace.
I'm sorry, I'm not sure I quite understand the question.
Yeah, I'm thinking about, well, what kinds of projects can you think of that governments would use eminent domain for?
For public parks, different ventures that necessarily might not serve the interests of the private owners, but serves the public good.
Okay, so imagine the government wants to build a park, and there's a particular location that they're interested in, but the landowner won't sell. Does that prevent them from building a park somewhere else?
No.
No, so they could do many of the things they use eminent domain for just by buying property from willing sellers. But there are some kinds of projects, think about like building a highway, or places where the particular location really matters, where if you didn't have the power of eminent domain, one landowner could prevent an important public project from taking place, or could hold the public hostage until they paid an exorbitant price. So what about the requirement of just compensation that we see in the Fifth Amendment? Why require the government to compensate when it wants to use property? Why couldn't we be like utilitarians, or follow Spock and say the needs of the many outweigh the needs of the few? And so, your property is more useful to the public than it is to you individually, so we're just going to use it.
Well, I think a lot of it comes from the fact that this wasn't just an American idea. This kind of has a lot of historical significance, even to colonial times. And so they had a distrust of the government. Back then, it wasn't as common where they would give just compensation. They would just kind of take things. So I think some of that distrust led them to kind of put that into the takings clause.
Okay, so there wasn't necessarily an obligation in English law to compensate, although Parliament often did compensate landowners when land was taken. But it seemed to be important enough that our framers wanted to have it spelled out in the Constitution. I mean, what if you didn't have a requirement of compensation? What if it was up to the government as to whether they compensate you when they take your property?
Well, then that leads to a bigger issue you kind of already have with that is, you already have a question of what is just compensation, but essentially there would be no parameters as far as what the government can give you, because they ultimately control what the price of that sale is going to be.
Yeah.
So it just kind of forced them to be fair in a certain way to at least, require the fair market value.
Yeah. So, one Seventh Circuit judge, Posner, who is kind of known for law and economics analysis, argues that if you didn't require compensation, that the government might overuse the takings power. That this would be kind of something they would like to do instead of taxing people. Because if you take property from somebody unpopular, you've ticked off one person. If you impose a tax, you've ticked off a lot of people. And so he argues that we need to impose the requirement of just compensation so that the government doesn't lean too heavily on eminent domain. Another issue that you hear raised is that if the government is able to decide when it will compensate and when it won't, that it would routinely compensate people who are kind of, politically connected or from, kind of powerful groups, but they would tend not to compensate those who are unpopular or from less powerful groups. All right, let's talk about Kelo versus New London Development Corporation. This is probably the takings case that has done the most to capture the attention of the public in the last, 30, 40 years or so. What happened to give rise to the Kelo litigation?
Well, we're dealing with the city of New London in Connecticut. Essentially, they had a naval base there that ended up leaving, moving elsewhere. So they lost, I think it was 1,800 jobs. And basically, economically, they were in need of revitalization. So there was a group put together, the New London Development Corporation, and essentially the city gave them a lot of funding to go ahead and come up with plans to economically revitalize the area. And in order to do so, they needed huge parcels of land. All this was kind of in conjunction with the fact that they had a company named Pfizer that was coming by to set up in the area. And so they were kind of hoping to kind of capitalize on that opportunity to kind of build around that company to revitalize the area. So there was a lot of land that they needed. Obviously, there's homeowners that were already on the land. So they went through negotiations with a lot of the homeowners in those parcels of land to get them to give up their land and sell their land. Although there was a coalition of people that got together, including Suzette Kelo and a lot of her neighbors who essentially didn't want to give up their land. So that's when they went through with the eminent domain proceedings to force the sale.
So what's the principal issue the Supreme Court has to resolve in this case? What's the legal question here?
Right. So the legal question is what constitutes public use? Does the plans that the New London Development Corporation have for that land? Does that constitute public use in those specific areas where the homeowners are?
Okay. Now, if you look at the language of the takings clause, it says, "Nor shall private property be taken for public use without just compensation." Technically, it doesn't say that you can only take property for public use, does it?
No, not necessarily.
Do you think it's fair to read that in as an implied requirement for any taking?
Don't think it's fair to read just from the language that's there.
Yeah, I mean, does it imply that public use is necessary for exercise of eminent domain?
No, it doesn't. It doesn't imply that it's necessary.
So, I mean, I guess you could say that, if you take the property for public use, you have to provide just compensation. But then, it would be kind of odd to say you don't have to provide just compensation if you're not taking it for public use, right?
Right.
So maybe they at least seem to assume that when eminent domain is exercised, that it's going to be for a public use of some sort. Right? So I want to talk a little bit about some excerpts from the briefs in the Kelo case, and think about the process of persuasion, right? So a lot of what you guys are learning to do is learning how to make arguments that people will find persuasive. So I want to pull up a passage from kind of a famous work on persuasion by Aristotle. Here we go. Aristotle's Rhetoric. So he says, of the modes of persuasion furnished by the spoken word, there are three kinds. The first kind depends on the personal character of the speaker. The second, on putting the audience into a certain frame of mind. The third, on the proof or apparent proof provided by the words of the speech itself. Persuasion is achieved by the speaker's personal character when the speech is so spoken as to make us think him credible. We believe good men more fully and more readily than others. This is true generally, whatever the question is, and absolutely true where exact certainty is impossible and opinions are divided. This kind of persuasion, like the others, should be achieved by what the speaker says, not by what people think of his character before he begins. Secondly, persuasion may come through the hearers when the speech stirs their emotions. It is towards producing these effects, as we maintain, that present-day writers on rhetoric direct the whole of their efforts. Thirdly, persuasion is effected through the speech itself when we have proved a truth or an apparent truth by means of the persuasive arguments suitable to the case in question. So one kind of summary of Aristotle's point here is that he kind of talks about three different kinds of persuasion that are used. There's ethos, pathos, and logos. So ethos, kind of an appeal to our sense of morality, of right and wrong, the good man proving he's good by what he says. Pathos, appealing to our emotions, or logos, appealing to logic, logical argumentation, and that those, kind of categories sum up the major ways in which rhetoric seeks to persuade. In a legal context, my old boss was a partner at the firm I worked for. Her name was Margaret McEwen. She's now ended up being a judge on the Ninth Circuit Court of Appeals. But she was really an effective advocate. And I remember her talking about how do you persuade people. And one of the things that she would say is that, judges really want to do more than one thing when they decide a case. They have multiple goals. One is they want to faithfully apply the law to their decisions, right? They want to do their duty as agents of the law. They want to have defensible legal positions that can be explained in terms that lawyers will understand and accept. But at the same time, they also are humans who want to do the right thing, right? They want to be persuaded that they are doing something good with their decision. And so when you're arguing a case, you want to appeal both to the judge's mind and to her heart. You want to show her that that ruling in your favor is consistent with the governing law and the precedent, but you also want to show her that it's right, that it's a good outcome. And so let's think about the briefs in the Kelo case. So, Mr. Julius, which side would you rather have been arguing if you had to be an attorney and you got to pick which side you were going to represent? Which side seems to have the better position from your perspective?
I think, from a logical standpoint, I think the city has a stronger argument.
Okay. So you think they have an advantage in terms of the law, the precedent seems to point their direction. Are there any advantages that Kelo's side has?
Well, absolutely. They have the emotional appeal. I mean, you have individuals being juxtaposed against, economic development. They're losing their livelihood, their homes. So,
okay. So let's take a look at the way that both sides kind of frame the argument in their statement of the question presented. So the petitioners, Kelo's side, they say the question presented is, what protection does the Fifth Amendment's public use requirement provide for individuals whose property is being condemned, not to eliminate slums or blight, but for the sole purpose of economic development that will perhaps increase tax revenues and improve the local economy. The question presented according to the respondent: does the takings clause of the Fifth Amendment forbid an economically distressed city from employing its eminent domain power to condemn and pay just compensation for private property in order to reverse decades of economic decline, create thousands of jobs, and significantly increase property taxes and other sources of revenue for the city, and to realize immediate structural and environmental benefits for the city and its residents? So is there any advocacy going on in the way that the parties are trying to frame the question presented?
Absolutely. I mean, so you have the question presented coming from the petitioners, and essentially their entire thing is framed around protection for the individuals. So what sort of protection is provided under the Fifth Amendment? And you also have where, within the question presented from the petitioners, they only talk about economic development. There's no sort of details. Meanwhile, on the respondent side, you have them going into explicit detail about all the different sort of, economic benefit for the public that's going to be there. And they claim the respondent frames their question presented more so around not so protection, but whether they're allowed to. So whether the Fifth Amendment forbids them from doing something, whether it's within their power to act according to certain ways.
Yeah, and so in their framing, the government wants to do something good for its people. Is the Fifth Amendment going to stand in the way and keep us from doing that?
Right.
Okay. Now let's read the first paragraphs of the petitioner's statement of the case. Petitioner Wilhelmina Derry was born in her house in the Fort Trumbull neighborhood of New London, Connecticut in 1918. Her family, the Ciavaglias, first moved to Fort Trumbull from Italy in the early 1880s. Mrs. Derry still lives in her home on Walbach Street, which was purchased by her family in 1901, as she has for her entire life. Her husband Charles lives there as well and moved into the house when the couple married 59 years ago. The Derry's son, Matthew, was born in Fort Trumbull and grew up there. He, his wife, and his son currently live right next door to Mr. and Mrs. Derry at 28 East Street in a home he received from his grandmother as a wedding present. The home has been in his family since 1903. Petitioner Suzette Kelo, a registered nurse, lives down the block from the Derrys at 8 East Street. She purchased the Victorian-era house in 1997, and since that time has made extensive improvements to it. She loves the water view from her home, the people in the area, and the fact that she can get in a boat and be out in Long Island Sound in less than 10 minutes. Wilhelmina Derry, Suzette Kelo, and their neighbors, the other petitioners in this case, stand to lose their homes through eminent domain to make way for private business development in the hope that the new development projects will create more tax revenue and jobs than the homes that currently occupy this peninsula of land along the Thames River. Petitioners have poured their labor and love into the 15 homes they own in total. They are places where they have lived for years, have raised their families, and have grown old. Petitioners do not want money or damages. They only seek to stop the use of eminent domain so that they may hold on to their most sacred and important possessions, their homes. So is that kind of just a neutral and detached statement of the facts? Or are they making arguments by the facts that they select and emphasize?
It's definitely definitely the latter. It's definitely not objective. It's definitely told in a way that makes the reader sympathetic.
Okay, so what are they emphasizing? What's the argument that they, even though it's stated as here are the facts, right? What's the argument that is implied in their selection and arrangement and presentation of the facts?
That this isn't really about just money or damages. That this is a whole. This is going to affect these homeowners in ways that they really can't be compensated for. So the burden that it's placing on them is something that can't be just paid back by the government. And also that the reason why these individuals are being pushed out of their homes is for private business development. And so and they talk about the labor and love that's been poured into the 15 homes. So, I mean, all those things.
Yeah, and so you mentioned that money really won't compensate them, and that's actually something that you see in the discussions of the just compensation requirement, that the government is required to pay fair market value for property, but there are a lot of people who have value wrapped up in a particular piece of property that the market won't pay for. And so market value arguably does not compensate everybody for what they actually lose when eminent domain is exercised. What are some of the things that they're pointing to here that you can't pay for, that things that would be lost by exercise of eminent domain?
I mean, the memories. I mean, it was purchased by her family. It's had been passed down. Lived there for her entire life. Um, their children were born there. I mean, it's those sort of things that really can't be compensated. The time and effort they put um, um, uh, into labor they poured into the property in the house is something that really can't be monetarily compensated.
Yeah. So there's a lot of history here, a lot of family history. Notice the emphasis on births and marriages and children living next door, and houses that were passed down within the family from one generation to another. And I think you're right. Also, the emphasis on the investment that people made in particular places because they were unique, right? That you can see the water from here, and you can get down to Long Island Sound in 10 minutes. And, those kinds of things, that the focus on neighbors, that, these are people who live in a community together, and that's going to be lost if eminent domain is exercised. Those are things that, money just won't compensate for, particularly if your standard is fair market value. Right? How about Ms. Brogdon? Are you with us today?
Hi.
Hi. So let's go down to where the petitioners introduce Pfizer. So this is further on in their statement of the case. They say, in discussions as to what would constitute the future uses in the development plan, Pfizer was the 10,000-pound gorilla, according to respondents' expert. Indeed, the development plan contains all of Pfizer's requirements that it set forth in agreeing to build its global research facility in New London, a luxury hotel for its clients, upscale housing for its employees, and office space for its contractors in existing buildings if no new ones are constructed, as well as the overall redevelopment of the Fort Trumbull neighborhood adjacent to Pfizer, in addition to other upgrades to the area that it demanded, renovation of the state park and sewage treatment plant upgrades. The NDLC estimates that the development plan, which is a composite of 6 alternative development plans it considered, will produce a significant economic impact in a city that is struggling economically, including the creation of jobs and between 680,000 and 1.2 million in property tax revenues. So is there an argument going on in this portion of their statement of the case? Are they selecting and arranging facts in a way that kind of makes some appeal to the reader?
For their argument, yes, because they talk about, first of all, they put like requirements in quotes, kind of saying that those shouldn't actually be requirements to be there. And then they focus on like the luxury hotel and the housing. And kind of, it seems a little over the top.
A little extra, right? So what do they want you to think about Pfizer here in the way they've described their role in this project?
That they're kind of coming into a city and adding all these unnecessary things, and then with the like redevelopment in quotations too, that kind of makes the argument seem like it doesn't need to be developed, and that the company's just coming in and taking advantage of all the area and space.
Yeah, the 10,000-pound gorilla. It's you almost get the idea of this economic bully kind of throwing its weight around, making demands, and not just simple demands, but we want a luxury hotel and we want upscale housing, so that you kind of get the sense that this is the rich, big, bad corporation coming in and twisting arms of politicians until it gets its way. So we've seen kind of pathos at work in the petitioner's case, right? They are appealing to our emotions with respect to the losses that will be sustained by the petitioners in this case, the things that they're not going to get to enjoy in the future if we take their property, and kind of making us look askance at Pfizer and the way they're kind of running roughshod over these small landowners. Is there a logos to the petitioner's position? Is there something that they can argue that is as a kind of a logical application of the law that at least could result in a ruling in their favor?
I don't really think so. I don't think they really talked about the law, and I don't think they really have like a legal argument.
So if you're the petitioner's attorney and you read the phrase public use, what would be your argument that this is not a public use of the property?
Well, I would probably contrast it to other cases that have done public, like more, I guess, public uses like a railroad or like a pipeline or something like that, and kind of try and say that those cases were all about creating, I guess, development in a way for like the greater good, whereas this all benefits that one company.
Okay. And in many kind of prototypical examples of eminent domain, you actually see the public getting to use property that's taken either in the form of, like a road or, a park or something like that. I guess there was going to be a park in this development, but a fair amount of the property was being taken to hand over to a private corporation that was going to be investing in the development process, I guess. And so I think to the extent there's a kind of a logical argument, it focuses on what does public use mean, and is this something we should classify as public use where it's really, a significant part of the property is being transferred to private entities for, their own private economic purposes. What about over on page 5? They give some scenario, or I'm sorry, I don't have pages on this, what I handed you, but they give some scenarios about how the logic of the respondent's position could play out in other circumstances. And so focus on the one that I've got here from their brief. While the district could use eminent domain in a blighted neighborhood, as noted, economic development condemnations are not tied to the condition of the area. If developers were more interested in Georgetown than Southwest, the city could condemn there. Georgetown's somewhat upscale shopping could be replaced by truly expensive designer shopping, more like that on Rodeo Drive in Beverly Hills. Georgetown's older townhomes could be replaced by taller condos and office buildings. Would successful businesses and viable homes be uprooted? It doesn't matter. The district intends the new development will produce more taxes and jobs, and that is enough. Have you been to DC, Ms. Brogdon?
I went during the government shutdown, so I did nothing.
Yeah. Have you been to Georgetown? Have you seen that part of DC before?
No.
So any thoughts on why they might focus on Georgetown as their hypothetical in the brief to the justices of the Supreme Court?
Maybe because they're familiar with the area.
So yeah, if you ever go to DC, Georgetown's a really interesting kind of historical portion of the city, and it has lots of kind of townhomes that are probably high value, they're very expensive townhomes, but they're a little bit older. There aren't as many new buildings. They've been there for a while. I'm suspecting that most of the justices have spent a fair amount of time in those Georgetown townhomes, right? They've got friends living there. They've been there for parties and events, and so they're trying to kind of bring home the implications of the respondent's argument in a place that the justices are apt to think of as, you know, worth protecting, something that shouldn't be just kind of bulldozed to make room for something more valuable. Okay, let's now take a look at a portion of the respondent's argument for a while. The respondent says, the respondent city of New London occupies 5.79 square miles at the junction of the Thames River and Long Island Sound in southeastern Connecticut. New London, which is geographically the second smallest of 169 municipalities in Connecticut, was once a center of the whaling industry and later a manufacturing hub. However, New London has suffered through decades of economic decline. Staggering economic woes, which include an unemployment rate close to double that of the rest of the state, a shrinking population, a dearth of new home and business construction, and the departure of one of the region's principal employers, caused the State of Connecticut Office of Planning and Management to designate New London a distressed municipality. In addition, local property taxes are the main source of municipal funding in Connecticut, but 54% of New London's land is tax exempt. Faced with this untenable economic situation, the respondent New London Development Corporation planned a development project for the city's Fort Trumbull section, which is located on a peninsula that juts out into the Thames River. NLDC is a statutory non-stock, non-profit development corporation with a volunteer board and no independent power of eminent domain. Under Connecticut law, a city may designate such a corporation to act as its development agent for an economic development project. A city may then authorize the development corporation to acquire real property through eminent domain in the project area in the city's name. Pursuant to this statutory authority, the New London City Council designated the NLDC as its development agent for the Fort Trumbull Municipal Development Plan and authorized the use of eminent domain on New London's behalf. The MDP was designed, in the words of the trial court, to provide an economic and social uplift for the city. The undisputed facts regarding the steady deterioration of New London's economy from the 1970s onwards demonstrate the dire need for such a project. These facts include the 1990 designation of New London as a distressed municipality, the steady decline of New London's population from a high of 34,000 in 1960 to 23,000 in 1998, its lowest since 1930. Its unemployment rate, 7.6%, almost twice as high as the overall figure for the state, 3% higher than the neighboring town of Groton. The 1996 closure of the Naval Undersea Warfare Center, located on the Fort Trumbull Peninsula, which employed as many as 1,500 people in the late 1980s. A sluggish labor market that has been outperformed by a wide margin by both the state as a whole and the surrounding region. 61% of the city's housing was built before 1950, with a high percentage of vacant housing. In addition to these citywide problems, the Fort Trumbull area itself suffers from numerous ills. An 82% vacancy rate for non-residential buildings and a 20% rate for non-commercial property, very low tax revenue for the MDP area. 55% of the buildings in the MDP area were built prior to 1950. 66% of the non-residential buildings were in fair to poor condition, and less than 12% of the residential buildings were in average or better condition. Since 1990, existing buildings in the area have undergone minimum private investment, with some sections of Fort Trumbull suffering from disinvestment and owner neglect. It's little wonder then that the trial court found New London to be a city buffeted for decades by hard times and until recently, declining prospects. The record is clear that New London was a city desperate for economic rejuvenation. The NLDC, which originally was established in 1978, was reformed in 1997 following the closure of the NUWC to assist the city in planning that economic rebirth at the site of the closed base. In January 1998, the first step in that rebirth occurred when Connecticut's State Bond Commission authorized $5.35 million in bonds to support planning activities and limited property acquisition, and a further $10 million in bonds toward the creation of Fort Trumbull State Park. The following month, Pfizer, a world leader in pharmaceutical development, announced its plan to build a global research facility in New London on a site adjacent to the Fort Trumbull Peninsula. Construction of the $300 million Pfizer facility began in April 1999. By the time the petitioners' properties were condemned in November 2000, the facility was almost completed. Pfizer staff began moving in early in 2001. So advocates are often telling a story. The petitioners are telling the story of the individual landowners and how their lives are wrapped up in the property that's being taken. What kind of a story are the respondents trying to tell here?
They're trying to tell, I kind of got three main things that they were pointing out. And the decline in the economics of the area was the overarching theme, I think, throughout. And then they talked about how they kind of like brought in the state's role in all of it, and how the state was supportive of, and kind of at the end they talked about the state board of bond, or the state bonds commission. So it seemed like they were trying to say the areas in economic decline and the state is behind trying to boost the economics of the area, and that the company's going to come in and be a benefit to the area. And then they also tied in like legal justifications and a legal argument for why they had the authority under the Connecticut law.
So do you think, just as at the level of stories, does that story work to rebut the story that the petitioners are telling?
I think it does. I think both sides are kind of telling drastically different stories.
Yeah. So is there something the respondents could do, or maybe if you were their advocate, you wish they could do to make their story even more effective? What's missing that the petitioners have that you don't have in the respondent side?
A personal connection. And I guess the respondents could take and say like what would happen to the people of the area. I guess like in the case book, there's a picture of the plaintiff's house, and I guess they just moved the house to a new place. So I guess you could talk about like what's going to actually happen to where they're moving people.
Okay, so that if they're investing in actually relocating the neighborhood instead of just bulldozing it or something. Yeah. I'm thinking about, the petitioners have all of these sympathetic individuals who are impacted by the government's action here, right? They can talk about the grandmother who's lived in the house her whole life, and the person who's invested in it because it's such a great neighborhood, and but there presumably would be people benefited if this redevelopment happens. There would be people getting jobs that they might not get. There might be people with, getting to live kinds of lives that they wouldn't get to live absent the redevelopment process. But you can't point to them in the same way, right? You can't put them in front of the court and say, here's somebody who would have a great job if Pfizer came in and redeveloped this area, or here's somebody who would live in a nicer home than the ones that are at Fort Trumbull now, right? Is there anything that the respondents could do to create more pathos in their argument?
They could, like you said, they can't really find people that would be employed, but you could kind of talk about like construction of the area, and maybe they're going to hire a local company, or just find people who lost their jobs. I guess there's a naval base. Maybe you can talk about people who have lost their jobs and how there's potential for them to be employed in the area by the company in the future.
Yeah. That's interesting. I hadn't thought about the construction angle, but apparently some of the work has already been done. Maybe you could find a sympathetic, construction company that's gotten work that helping with the redevelopment process or something. So now the book has an excerpt of the majority opinion by Justice Stevens. What does the majority decide in the Kelo case?
The majority decides that the use for the taking by the city was constitutional and is a public use. And
so do they deny that there's a difference between takings for public use and takings for private use?
No.
Okay. And so, and it acknowledges that you can't take property for private use. So how do you distinguish according to the majority? How do you know whether it is a legitimate exercise of eminent domain for public use or illegitimate private exercise?
I think that was kind of part of the difficulty. And they talk about the government can't take property and then immediately transfer it over to a private company. But they also say that it's kind of hard to distinguish between if there's a government takes property and then waits a while to change it over to a private company, and then it does economically benefit people, like where the line is drawn.
So they talk about a couple of prior precedents that the majority kind of sees as kind of leading almost inevitably to the outcome in this case, right? Mm-hmm. One is Berman versus Parker. What was the Berman case about?
This was in Washington, D.C., and there was the government took in, and it was seems like a much more blighted area than in this case, though. And then they constructed streets, schools, and other public facilities, and then the rest of the land they leased or sold to private properties.
Okay, so that is kind of viewed as a case where the government was trying to address what's sometimes called urban blight, or clear out, slums or whatever terminology, but that they're trying to take a part of the city that has become really problematic as a place to live and turn it into a better place. And the court upheld that exercise of eminent domain. What about the Midkiff case from Hawaii? What was the Hawaii government doing there?
They were trying to keep land out of, I guess, a few. It says in order to reduce the concentration of land ownership. So like it's a little bit different than the cases we're dealing with, but the government took land out of the hands of a few people and then transferred it to other people.
Okay, and so, since Hawaii consists of a set of islands, there's a limit on the amount of property available. And over time, large chunks of that had fallen into the hands of a small number of families who kind of controlled, lots of real estate on the islands. And so the Hawaii legislature was trying to use its eminent domain power to break up the real estate market a little bit, to transfer property from the concentrated ownership so that people could purchase the places that they were renting under certain circumstances. Right? So is there a test, though, in the majority opinion, about how we know whether a taking of property is for public use within the constitutional provision? Does it actually have to be used by the public after it's taken?
No.
No. So public use, then, how do they define that in the majority opinion?
I'm not sure.
Let's see if I can find this quickly over on page 619. So take a look at the second paragraph in part 3. The disposition of this case turns on whether the city's development plan serves a public purpose. Without exception, our cases have defined that concept broadly, reflecting our longstanding policy of deference to legislative judgments in this field. So is a public purpose the same thing as a public use?
No.
Yeah, I guess it depends, right? I mean, the public is using it to accomplish its purpose, I guess. But if it all goes down to what do you understand public use to mean, and does it require something more literal than what the court? But here the court seems very deferential. If you can identify a public purpose behind the transfer, then it is a public use, right? And so what about in this case? What's the public purpose that justifies exercise of eminent domain in New London?
Increasing economic benefit.
And after this case, what would it take to convince a court that the public use requirement was not satisfied? Can you imagine a case where the court would say, you can't exercise eminent domain because this is not for public use?
I think it's a pretty broad standard, and I think they can get away with kind of a broad range of things saying that it's for the public use.
So in a part of her opinion, dissenting opinion that's not in the book, Justice O'Connor says, well, if you look at what the majority says is the test, really their test is whether the government has a stupid staff. What do you think is the point she's making there?
I have no idea.
So if, do you imagine that it's hard for, a bright government employee to figure out some public advantage served by any project they want to pursue?
No, it's probably not that difficult.
Yeah, so I think basically what she's arguing is, under the majority's test, as long as, the government employees are not really, really dumb, they will be able to come up with some plausible argument that there is a public purpose behind an exercise of eminent domain, right? So, I mean, have they effectively taken the public use requirement out of the analysis? Or could you imagine a situation where a court would say, no, this was not for a public use?
I don't think they've taken the public use requirement out. They've just kind of seems like they've put the focus on state legislatures on setting what the public use is for their state.
Yeah. So very deferential, which is actually, that's kind of been a trend in, in constitutional jurisprudence since the 1930s. Economic legislation in particular, a great deal of deference shown to economic judgments by local, state and local governments. So note 3 after the case, what kind of a public reaction has there been to the Kelo opinion?
There's been an increase in state legislatures defining public use and restricting it. They said through state constitutions and legislatures.
Okay, and so the Kelo opinion was actually not popular with the general public, and there was a lot of backlash around the country that led to legislation and judicial responses kind of narrowing the concept of public use, at least under particular states' laws. Let me pull up a Georgia statute that I think was from that post-Kelo era. So Georgia Code 22-1-1, they define the meaning of public use, and they include lots of things, possession or use by the general public or state or local government, use of land for the creation or functioning of public utilities, opening of roads, construction of defenses, acquisition of property, remedy of blight. So they would allow things like the Berman case, but then subsection B, the public benefit of economic development shall not constitute a public use, right? So fairly kind of a minimalistic response in Georgia. They didn't do a lot, but they at least seemed to codify the position that the holding of the New London case is not binding in Georgia, is not good law for Georgia purposes. Right? So who won? I mean, could you make the argument that the petitioners lost the battle, but in some sense won the war?
Maybe. I mean, I don't think it says what Connecticut decided to do after this case, but maybe you could look at what the state law in Connecticut, if that changed at all after the case. And then I think in the state court, they were able to keep part of their property and only had it taking on one of the areas. So I guess you could make that argument.
So I think actually the the redevelopment that was planned for the properties that were an issue in this case didn't get completed. And so, you know, that they were planning to do things that never actually came to pass. I haven't kind of followed up with what's happening recently, but you know, it may be that they found another use for that property, but at least the plans that they were talking about didn't end up coming to fruition in the form that they envisioned, right? So any questions, comments about Kelo, about the arguments in the case, about the response to the case? All right. Well, it has been fun to see you all. You know, I don't mind the asynchronous lectures, but there is something nice about seeing your faces. So thanks for showing up on a Wednesday morning. We'll probably do one more of these one of the days next week. I'm not sure, Monday or Tuesday. Probably Tuesday we'll get together for our last class online. But I have also been recording this session, and so I will put this up on our ELC page for anybody who wants to go back and look at it later on. Thank you all. Have a good day. See you next week.